Bidas.
Third, Ms. B. Das. Why are you praying for adjournment?
Sorry, my lord, I'm not aware this case, so in this council.
Third, Mr. B. Das, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after a deed. Yes. After. Yes, Mr. Khan.
Attempt I. Liability loss. And the last day, your lordship has made a query as regard the bank account, whether it is belongs to the petitioner or in the name of coming engineering.
Hmm.
My friend was there, lordship. To that effect, lordship, we have already filed an affidavit that is on record, lordship. My
Yeah,
lord,
fine.
in
Fine.
fact,
Where is the additional affidavit?
my lord,
Where is it?
in paragraph 3, lordship, we have stated.
That same bank account.
My lord, that was belonging to in the name of lordship coming engineering.
You have the order of the copy. Do you have copy of the order of the co-accused?
Yes, lordship. On the last day, we have some.
Yes, Mr.
My lord, here,
In the FIR,
yes, my lord.
the first informant has said that so and so account has, let us go to the FIR.
Yeah.
Where is the FIR?
Page 9, my lord.
FIR page 9.
Page 9. In para, at page.
Well,
At page 11, last line, read last line, considering the same. I, the undersigned, so and so, opened a bank account, number so and so. This bank account 719760649 was opened by the informant.
11 is something different in my vision.
same.
Something I know what you say.
This is the account which is
Yes,
operated by Madhurya Das.
Yes,
Same.
And
Same
they are-
account. So how it can be fake? He has alleged that Madhurya Das,
Hmm.
along with other two co-accused,
co-accused.
have opened a fake account.
Yes.
But in the FIR, he has himself stated that
Considering the same, I understand.
But
Idea.
that account was opened in the year 2002,
so it was opened by the informant
So-
himself.
22.
Informant.
But in
Who opened that
But
account?
not opened by the present petitioner
Okay.
in the name of the company. And I being lordship, the employee has operated this bank account in representative capacity. That I have stated, lordship. Yes,
So
there was a
What this para means, last para of para 11, read para 11.
there are 11 of page number, lordship.
Page 11, last para.
No, no, last slide. That our firm coming engineering.
Yes.
So and so, in spite submitting supply bill,
This is the statement of first informant,
my lord.
who is saying that our firm coming
Yes,
engineering.
coming
Yes.
engineering.
Read it. In spite of submitting,
In spite of submitting supply bills on regular interval in the office of government marketing corporation limited Ambari have not received any payment from the said office since 2020 till date. Considering the same, I undersign so and so open a bank account so and so. He himself opened,
Yes, so it cannot be.
and
a
that
paid-
has been operated by the present petitioner in representative capacity.
My lord, in later paragraph, that the undersigned being a lawful attorney of Kameng Engineering, Bhalukpong hereby state affirm that the said firm has no other registered office other than Bhalukpong, and also the firm has no other bank account other than maintained at the State Bank of India, Tinsukia branch.
Now, these two are
The
contradictory.
Contradictory,
In the first paragraph, he says undersigned opened a bank account
yes.
and deposited 4 checks. What it means,
my lord, I
He
think
himself
while
contradicted.
what it means. He's saying that I have opened account and deposited 4 checks to it.
For say,
And later on, he's saying that we don't have any other account and
No.
this is a fake,
except this free one.
and this is a fake account.
But everything was going well, only because of lordship, some dispute arose between this lordship, Prime Minister Prakash Agarwal and the informant. This instant affair lordship has been lost, and I have been involved in this case lordship. In fact, all this lordship.
Case there is there.
Kaiser is not here, my lord, for motion,
Let him appear.
my lord.
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. R.J.
RR prosecutor.
R.R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure from 1973 has been filed by the petitioner Madhunjo Das, who is apprehending his arrest in connection with Bhangangaon PS case number 31/2024 under section 120B/420/468/471 of the Indian Penal Code. The gist of accusation in this case is that one Shri Sandeep Kumar Garodia, who is the lawful attorney holder of কোর্ট এ মার্ক করে দিছে, এটা পুরা এ টু কোর্ট করে। The allegation in the FIR is also against the authorities of eight all of changes আছে, হ্যাঁ?
My lord, your lordship read this thing, my lord, considering the same R undersigned, the next page, RG Borwa wrote. Something is. Something is missing there, my lord. I don't know. My lord.
Okay, sir.
Undersigned cannot be RG Borwa wrote, my lord.
Page number, so internal page number.
Some page may be missing.
Yes, my lord. Some page may be missing, my lord.
Oh,
Original process is not okay. Original process.
Something is missing, my lord.
you have not annexed the FIR completed. Some page is missing, though there is a continuous pagination. Okay, we'll find it out when the CD comes.
My lord.
Otherwise, as other two have already been granted protection.
My lord.
Let him also appear.
Same original.
কিবা এটা আমাকে দিওঁতে
Same thing lordship in original lordship.
হ'ব চিঠিখন আহিলে গম পাম।
Let the city come. Next, after me, quoting me. Allegation in the FIR is also against the authorities of Assam Government Marketing Corporation Limited, that they have also collided with the accused persons in facilitating the payment of phone numbers of check of Kameng Engineering, Bhalukpur, amounting to 1,73,11,010 only to the co-accused, namely, to whom the payment was made?
Payment was made to Prakash Agarwal
Co-accused, namely Prakash Agarwal
and his son Ishan Agarwal.
and his son Isan Agarwal. Learned counsel for the petitioner has submitted that petitioner is the employee of Kameng Engineering Bhalukpur,
Right.
and he has only operated the account of Kameng Engineering on the directions of the first informant,
First,
namely Sandeep Gadodia
my lord.
himself. It is also submitted by learned counsel for the petitioner that in the meanwhile, both the co-accused, namely Prakash Agarwala and Kameng Agar and
Ishan.
Ishan Agarwala have been granted interim protection by this court. The other two cases are fixed today,
Look, it was fixed today, but not listed.
not listed. Okay. Interim protection by this court. It is also submitted by the learned counsel for the petitioner that the co-accused persons had executed the work and authorization letter to receive payment on behalf of the first informant in the affair was also given to the co-accused Prakash Agarwala. And as per the said arrangement, under the directions of the first informant, the present petitioner transferred the money to the account of the co-accused after they executed the work orders as per the memorandum of understanding between the co-accused Prakash Agarwala and Sandeep Garodia. Stop. Learned counsel for the petitioner has also submitted that the FIR has been lodged in a civil case which has arisen between the informant and the employer of the present petitioner, namely Prakash Agarwala. And the present petitioner has been made an accused unnecessarily in this case. He has also submitted that the present petitioner is ready to cooperate with the investigating officer. On the other hand, learned additional public prosecutor has pointed out certain discrepancies in the copy of FIR annexed with the bail application and has submitted that perusal of the case diary would be necessary for consideration of the instant bail application. Let bail application stop, hence call for the case diary fixing
On 17,
17/5 for 5/25/24 for case diary. However, considering the fact that the materials on record shows that there was a memorandum of understanding executed between the Kameng Enterprise and the firm of the co-accused Prakash Agarwala, and the present petitioner appears to be only an employee of the first informant's enterprise, Messrs. Kameng Enterprise. Full stop. Further, it also appears that as other two accused persons have already been given interim protection, the necessity of custodial interrogation may not be there if the petitioner cooperates with the investigating officer. Stop. Hence, the present petitioner, namely Madhurya Das, is hereby directed to appear before the investigating officer of Bhangagor PS case number 31/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time in the event of his arrest in connection with Bhangagor PS case number 31/24, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1. Fix this matter again on 17th of May.
Can we take with another lordship Prakash Agarwal? AB. It was.
No, I don't know the fate of other two cases.
I also don't know.
Same.
Interim or pending?
Let this case be tagged with the
AB.
case record of AB case number 892/2024.
Oblast.
May I please your lordship? Lord, petitioner was inside the jail since 2/2021. Today is about 3 years, 3 months, 4 days. In this case, lordship already passed the order and all the quick released by this honorable court.
Of the same case.
Same case. Last occasion it was listed before your lordship.
How many co-accused are there?
There are lordship 4, no? No, 4. Total 5 accused persons are there. Lordship will find at page number 26 of my petition. Again, 6 final complaint filed. Out of 6, 1 was absconder, lordship, declared as absconder. Then 5 were arrested. And out of 5, already 4 granted bail by this honorable court.
Who was declared absconder?
Lordship,
Who was declared absconder?
not declared as absconder, this person, they have written that
One-
accused absconding.
Okay. He is not before us.
No, sir. I'm the accused number 1, Surendra Kumar. I was in the vehicle where from the contrabands were intercepted. And that was driven by Lordship accused number 2 at page number 26, 2 and 3. And these persons were together inside the vehicle. And then Lordship, 2 other persons were intercepted on the 4 and 5, intercepted on the basis of the statement of these persons. So all the persons released by this honorable court, except one, Jamal Khan, Lordship, by other court. Then Lordship, this person is suffering from some illness, Lordship, report also received by this honorable court.
What ailment?
That is the some hydrocele, the problem in the testicle also. One is today.
Yes.
Is
Your submissions are same submission.
Lordship, some different submission is also there.
No, for
is
the
he,
petitioner.
only one submission is there. He, at the time of filing this petition, he was is it about 67 years old.
67.
Lordship. And operation is required as per our information also. And to his choice, this honorable court may allow him to operate him in outside of the jail Lordship, as per his choice. And regarding the delay is there, Lordship, our submission, we have submitted, we're going to submit the order of this honorable court in where all the citations are mentioned also regarding delay in incarceration.
Okay. One, give a copy of one such case.
Yes, of course.
No further submission.
The
The delay plus he's suffering from
illness,
ailments.
yes,
Okay. Yes, please.
and all the persons released,
And co-accused are.
yes.
Absolutely. Let me come to page 52.
Hmm.
The bail application,
Allegation.
paragraph 60.
Page 52.
Page 52, paragraph 60.
Roll.
Para 60.
Not 60.
How final?
Role of the. Okay.
Roll of the accused.
Okay.
Surendra Kumar petitioner 60 that seized 117.650 kgs of ganja, which is a commercial quantity seized from the truck bearing registration number so and so, and which was in conscious possession of Surendra Kumar and 2 others. So the contraband was seized from the conscious possession of the petitioner. Now, Lordship, directly I am coming to one of the judgment of Honorable Supreme Court. The judgment is passed by 3 judges bench. Lordship may come to paragraph
Number
11. To state by NCB versus Pallabid Ahmed Arimutta. Next we come to paragraph 11.
Yes.
22. 10/1/2022. Let me please to note this judgment was passed by 3 bench judge. The full bench of Honorable Supreme Court, paragraph 10, paragraph 11.
NCB versus.
NCB versus Pallabid Amrita Ahmed. Married lords. In this case, Lordship, Karnataka High Court granted bail to the 4 accused persons. Then NCB filed cancellation of bail before the Honorable Supreme Court. Then out of 4, bail application of 3 was application of the NCB was dismissed with respect to accused number 2. Married Lordship, paragraph 11.
Yes.
However, the evidence brought before us against Muhammad Afzal, accused 2, respondent in SLP number so and so, subject matter of the second case, that is NCB case number so and so, who was granted bail by order dated 8 January 2022, will have to be treated on an entirely different footing. There are specific allegations leveled against the said respondent regarding
recovery of substantial commercial quantity of drugs from the rented accommodation occupied by him, pursuant to which he was arrested on 16 June 2019. This aspect has been completely overlooked while passing the order dated 8 January 2020, wherein the only reason that appears to have been weighted with the High Court for releasing him on bail is that the case stand on the same footing as accused 1, 3, and 4, who have been enlarged on bail by the order dated 11th October 2019, 16th September 2019, and 9th September 2019 in connection with second case registered by the department. We are of the firm view that accused number A2 cannot seek parity with the aforesaid co-accused, and no such benefit would have been extended to him in view of section 37 of the Act, which has been found to be in conscious possession of commercial quantity of psychotic substance as contemplated under NDPS Act. This being the position, the petitioner NCB succeeded in SAB number so and so. The bail granted to the respondent Muhammad Afzal A2 is cancelled forthwith at this stage, and it is directed to surrender before the session court so and so. So here
Why he was granted bail by
he
the
was
High Court?
granted bail on the ground that other co-accused have been
Co-accused.
granted bail
Why other co-accused were granted?
because nothing was recovered from their position. And Lordship may
Okay.
come to paragraph 10.
Para 10.
Yes, it has been held in clear terms in Tufan Singh versus State of Tamil Nadu that a confessional statement recorded under section 67 of NDPS Act will remain inadmissible in the trial of an offence under the NDPS Act. In the teeth of the aforesaid decision, the arrest made by the petitioner NCB on the basis of confessional voluntary statement, the respondents or the co-accused under section 67 of NDPS Act cannot form basis of overturning the impugned order releasing them on bail. The CDR details of some of the accused or the allegations of tampering the evidence on the part of the one of the respondent is an aspect that will be examined at the stage of trial. For the aforesaid reason, this court is not inclined to interfere with the order dated so and so
So others were released on the basis,
of 67
67.
They were arrested on the basis of 67
but
statement.
this was he was the main accused.
He was the main accused and narcotic was recovered from his conscious position.
Okay. But in this case, the ground for release is different.
No, Lordship, here my learned friend has argued that there is a delay in trial. And regarding medical,
He may not get the benefit of parity as per
Yes.
this judgment.
yes, Lordship.
The
Will not be-
judgment says that parity in itself may not be a ground
Ground.
if the accused is differently placed.
Differently. Absent paragraph 16. So this is my first argument. Second, Lordship, in many judgment, Lordship has granted many accused on bail on the ground of delay. Lordship, in my humble submission, in none of the, there is no precedent has been laid down by the Supreme Court. What is the delay? That has never been defined in any judgment.
Yes.
So, and in Gurwan Singh, Lordship, on last occasion I placed that in case of heinous crime, delay in trial cannot be a ground for seeking bail.
In which case,
In Gurvat Singh, Lordship, I'll place the judgment. On last occasion, I'll place that judgment. Lordship has occasion to consider that also. I'll supply copy, Lordship. Gurvinder Singh.
that's
And I've cited many judgments. This is one of the judgments. And Lordship, with regard to Article 21, I'm relying on one judgment of Honorable Supreme Court, which is passed by the full bench, which says Kalyan Chandra Sarkar versus Rajesh Ranjan, reported in 2005 to SCC page 42. This is again a full bench judgment. 2005 to SCC page 42. The title of the case is Kalyan Chandra Sarkar versus Rajesh Ranjan. In paragraph 18,
একটু check করো, please.
Yes, para 18.
Paragraph 18. It is fertile that the personal liberty cannot be taken away except in accordance with the procedures established by law. Personal liberty is a constitutional guarantee. However, Article 21, which guarantees the above right, also contemplates deprivation of personal liberty by procedures established by law. Under the criminal law of the country, a person accused of an offense which are non-bailable is likely to be detained in custody during the pendency of trial, unless he is enlarged on bail in accordance with law. Such detention cannot be questioned as being violative of Article 21, since the same is authorized by law. But even persons accused of non-bailable offense are entitled to bail if the accused concerned come to conclusion that the prosecution has failed to establish a prima facie case against him, and if the court is satisfied for the reasons to be recorded that in spite of exercise of prima facie case, there is need to be released such persons on bail, where factual situation requires to do so. In that process, a person whose application for enlargement of bail is once rejected is not precluded from filing the subsequent application. So in my humble submission, article, if he is arrested following the due process of law, then and the offense is non-bailable, then delay in trial cannot be a question. And Gurvat Singh, Lordship clearly says that although it is not related to NDPS, but the word used by the Honorable Supreme Court, that in case of heinous crime, a delay in trial cannot be a ground for seeking bail. And regarding Lordship medical ground, Lordship may please to come to page 83, I think. 85. Is a medical advice slip.
No problem, হলে কম নেবে তাকে।
85.
85, last page of the bail application.
Though it is advice slip, but report received by dishonorable court.
Make me complete you some,
Hmm.
I am not
No.
objecting, I am not interfered with your argument.
But this is, you have a second
Whatever
offense,
they've been arranged,
right?
let's me please to see a chronic low back ache
Hmm.
out of radiopathy. Lordship here in Guwahati Medical College is one of the finest medical college in the Assam, Lordship.
Hmm.
Any treatment that can be provided to him, Lordship may direct the authority to avail all the medical facilities to required by him. Lordship. Whether this can be a ground for releasing on bail and treated as per his own choice. And this is not a simple case of other offenses. And probably as submitted by my learned friend, the report has come. Lordship may present.
In report, it is shown that he is suffering from hydrocele.
So that treatment is also available in medical college.
Yes, yes, that is available.
বলে,
Provide.
বলে, ও মা, আপনারা বসতে দিন।
Gross right side hydrocele with mild left side hydrocele.
Also may direct the authority to provide him all the best medical facilities available in Guwahati. Lordship.
Okay,
That
But
can be-
despite his choice, he has some choice.
let him complete, otherwise.
So, Lordship, regarding medical, Lordship has seen the report and others.
Okay,
And here in Guwahati Medical
so
College
your submission is that medical ground in itself cannot be a ground.
cannot be a ground, and the Lordship, if it is his fundamental right to avail the best medical treatment. If the state has not cannot provide, then Lordship may consider allow him to take medical treatment as per his choice. But when it is available in the medical colleges and others. And regarding delay, I have submitted before your Lordship, and with regard to parity also.
Now it is 3 years, 3 months, 4 days.
Yes, Lordship. Lordship, in this aspect.
How
I-
many witness?
Lordship, here,
Out of
out of,
out of
How many
11.
listed witnesses are there?
I'm Lordship, informing.
It's still not okay.
Listed not in annex. No, this-
11 witnesses cited. Out of 11, 4 examined.
Lordship, in this space, I want to submit that earlier there was no law with regard to NDPS case from Satyendra Prasad until Supreme Court passed order that
36.
in case of Satyendra Prasad until Lordship, that 436 capital A will be applicable in case of NDPS case also. And Lordship knows section 436A, which says that.
তারা যে খবর নিয়ে দিয়ে নিযুক্ত করে দিল।
Yes,
Okay,
নাই আমি না আমার রেডি হল আপনার লিস্ট
okay.
Notes 436 says that if the maximum the 50% of the what's the reading.
লজিক aware about
You want to make it part heard again,
yes
both of you,
I don't want
both of you.
no I don't want my only simple submission
No, you have already made your submission.
that
If you don't want to make it part heard, don't.
no I
repeat-
don't want to pardon.
Then don't reply to his submission.
Only lordship, one judgment lordship passed by this honorable court by Justice A.D. Chaudhary, and that was rejected. And
Okay, let him submit first.
Lordship 436.
I'm extending it to 5 minutes only. Otherwise, either it will be part heard or
Taken up tomorrow. Lordship.
no lordship, always I cannot wait for him lordship. That is
No,
the problem. He
your
will not be
submission is
available. Lordship.
regarding 436A.
Yes, sir.
Anything
Lordship,
else?
then Lordship may hear today if my learned friend and objection.
Yes,
for my-
I have opposition always lordship. In each and
No,
every
lordship,
court, he
today,
is not
lordship-
available for first time.
Lordship,
Lordship.
division bench was going on. All were waiting. Whether I am responsible for that? That should,
No, you are not responsible.
yes, Lordship, then why such type of,
Always lordship.
yes, always. What will take action
You,
against me?
you kindly make a submission
no,
to your
lordship.
lordship.
This is the way of Lordship.
Always
criticizing
we are
the country.
waiting before this honorable court. Honorable court also aware about these things. Lordship.
No, don't fight among yourselves.
Yeah, I'm
Lordship,
not
this is the
fighting.
way, okay,
You
this is the way
make-
of submitting.
Make
Lordship.
submissions to me.
Yes,
Yes,
Lordship.
If I understand, it will be,
Already more due.
My
Already
more আছে বাকি আছে।
cook.
Lordship 436 say. Maximum period for which and
how much time will it take? If you are going to take time, we may
will
fix
take
it
time.
tomorrow.
it will take time.
And tomorrow he has fixed just now in court number 15 at 2. I have one matter in the morning. Then he will again busy. The lordship, it will not
But
list.
he has to be heard.
He has to be hard. If lordship permits a few more times, lordship, then today may be complete.
I have work to be done in
Yes,
chambers.
I know that, lordship.
I have 2 division bench orders to be dictated in
So
chambers.
we follow the roster also. Nobody
I-
can,
I have to follow.
yes, Lordship. Everybody is,
Now, how much time will you take?
it will take another half an hour.
Half an hour is too much.
No, if Lordship allows, then if Lordship wants.
No,
to
no, there is no question of not allowing.
No,
If
because I want to clarify something, look,
Yes.
because Lordship has.
I want to also understand what,
Yes, Lordship, that is, whether Lordship is granting bail or rejecting bail, I am not concerned. My concern is to place the SHO Lordship with the correct law.
heard Miss S. K. Nargis, learned counsel for the petitioner. Also heard Mr. S. C. K. L. learned counsel, standing counsel NCB. This hearing remained inconclusive. Let it be listed. When should I list it?
Friday, lordship.
Friday. Let it be listed again on Friday as part heard matter. Part heard matter.
Lordship,
Then I take this one.
Other matters, registry will give that.
Lordship.
My lord, only a small submission, my lord. Item number 6, my lord. The co-accused has already enlarged on bail on 19/4, my lord. And today is 51 days, my lord. Item 6,
I am not taking up matters now. It has to be, you
my lord,
take,
let it come tomorrow, man. Yes,
because I have no control over roster.
yes, yes,
I am
I understand.
in division bench.
Yes.
So you have to make request to the registry. I'm leaving it to the registry. You make a request to the registry. If it comes tomorrow, I'll take up tomorrow. Otherwise,
My lord,
as and when it is listed,
My lord.
I'll take it up.
my lord, so far as interims are concerned, that.
Interim shall continue.
Fine.
Interim shall continue. You make a prayer.
Okay. Oblige me.